Good afternoon, everybody. My name is Clare and I'm with the School of Law and Government. My research question is the current exercise of the inherent jurisdiction of the High Court compatible with and capable of vindicating children's rights? I think it's very clear from this title that this is very much so a legal dissertation, so I'm very much so part of the law part of the School of Law and Government. I'm actually going to address 3 points. The first point is, what children am I referring to? The second point is, what is the inherent jurisdiction and what does that have to do with anything? And the third point is, what rights are relevant within this context? So the human rights of which children, my first point. The children that I'm talking about are very, very small in number. However, they are adolescents, generally between the ages of 13 to the ages of almost 18 years of age, who have seriously challenging behaviours and serious conduct disorders. And this behaviour is so extreme that what is required is serious intervention and therapeutic supports. And it is considered that these needs are best met by being detained in secure care facilities, and this is done so by order of the High Court. And these children are detained not just within Ireland, but also in the UK. And by secure care, I mean that they are deprived of their liberty because they cannot come and go as they please. In relation to the inherent jurisdiction, my second point, it must be remembered that any time the court makes an order, particularly a detention order, there has to be a legal basis for that. So in relation to these cases, the inherent jurisdiction is actually the basis for the children's detention and the orders that are made. What is the inherent jurisdiction? Well, it's a power that the court has, only the High Court, under the Constitution. When these cases first emerged during the late 1980s and also the start of the 1990s, the court was in a really difficult position because it had no legislation to help it out, no supports, and yet there was serious welfare issues with these children, so it had to do something. So that's when it said, we have to use this power that we have, which is called the inherent jurisdiction, so that we can actually address the needs of these children. And it did do so, and it still does so today. Of course, the issue is that it's a very malleable, flexible power that the court has, but it has to be. Because if it isn't, how can it possibly address the needs that it needs to address? But of course, on the flip side of that, where are the limitations? And quite simply, where are the boundaries? This leads me to my third point. What rights exactly am I talking about? I'm actually looking at a human rights framework within which I'm going to look at the rights of these children to be heard, particularly in the court process, because all of these matters come before the court for regular review. What about their right to education? Bearing in mind these children are detained for months on end, sometimes it's longer than that. What about their right to information? Are they kept up to date with what exactly is happening to them? Bear in mind they have no freedom and their liberty has been deprived. What about their right to healthcare? And finally, I'm going to look at the right of access to family, also bearing in mind that sometimes these children are actually sent to the UK. Of course, what we have to consider in relation to that is that we have to look at the interaction of these rights. And not only that, rights have to be balanced. In addition, we need to consider what are our obligations internationally as well as nationally. We don't live in a vacuum anymore. We have the European Court of Justice, we have the European Court of Rights. We also are signatories to many conventions. That has to be taken into account as well. And of course, it always, in terms of legal analysis, merits looking at other jurisdictions. How do other countries deal with the same problems? That needs to be considered as well. So essentially what my research is looking at, it's looking at the vindication of rights within this framework for a very, very specific group of children. Even though they are small in number, they are vulnerable within this very malleable, flexible jurisdiction or power that the High Court has over these cases when it monitors them. I must say that even though these children are vulnerable, they are extremely dependent. And they are dependent on other people to do the right thing for them at every single step of the way and at every single stage of the court process, and also afterwards. That's why this is particularly relevant. And therefore, with that in mind, what I'm going to leave you with is a few lines of a poem that was written by a lady, KW, who was detained in a secure care facility in the UK. Her case was coming up for review in the Irish courts. She wanted to come home. And this is only an extract, and it says, "This is not the kind of life I want to lead, and this is not the kind of treatment I need. I miss my culture, the Irish dance. Let me come back, let me have a chance. Please do not make me stay here another day. This is all I have to say." And it'll be good to know she did get home. So that's all I have to say. Thank you for your attention. Thank you, judges.